This video was intended to inform and educate the public.
Welcome back to the Junkyard News. In today's video, we're going to talk about a California Supreme Court case that just smacked California cops a good one. Let's get into it.
Hey, what kind of work do you do? An individual of your particular ethnic persuasion.
Where'd you get the car?
And the suit.
I stole them both. A car from your wife, suit from your grandmother.
Hey, what do we have here? Concealed weapon?
Hey, it's his grandmother's suit.
And what's this?
Probably drugs.
Listen, I have rights and I demand to see my lawyer.
The California Supreme Court just told California cops that people cannot be detained just for trying to avoid the police. Picture this. Cops are driving around on the beat, right? One officer in the car notices somebody down the street. They make eye contact, and the guy darts out of view. Cop's thinking to himself, oh, he's avoiding us. He's up to something. Court says that alone can't be suspicion of anything. You have no right to stop, detain, arrest, purely because somebody is trying to avoid you. So now in California, police officers cannot detain someone on the street just because that person tries to avoid contact with them. So says the California Supreme Court. The decision has immediate implications for police officers working all across the state, restricting the grounds under which they can stop and hold people for questioning. It could also affect other litigation in which arrests are being challenged, particularly when people of color or minorities allege that they were detained simply for trying to avoid contact with police. Someone acting nervous or attempting to conceal themselves can still be relevant context for officers, but those actions alone do not constitute reasonable suspicion of criminal activity. The High Court in California says officers may still consider what they see in plain view, and also can approach people in public and engage them in consensual conversations if the person that they are talking to consents, and take note of their appearance and behavior. But absent probable cause, the person is constitutionally protected and empowered to just go on his or her way. Let's talk about the decision. In a case that was brought by a Los Angeles man arrested on suspicion of having drugs and a gun after police said he tried to hide from them, was immediately blasted by the union that represents rank-and-file LAPD officers who called the High Court out of touch. The LAPD did not respond to news agencies for a request for comment. Now, Richard Fitzer, who's an attorney for Plaintiff MARLON FLORES, praised public defenders who worked this case initially and called the ruling a vindication of the rights of minorities. The outcome was possible, he said, because of the Racial Justice Act back in 2020. It was a California law that prohibits discrimination in the state's criminal justice system based on a defendant's race, ethnicity, and national origin. Now, Justice Kelly Evans, the High Court's newest member, wrote in a concurring opinion joined by 4 other justices that said many individuals, including and particularly people of color and or minorities, commonly hold a perception that engaging in any manner with police, including in seemingly casual and innocuous ways, entails a degree of risk to one's own personal safety.
People who are scared to talk to the police.
In layman's terms, it's natural for people to want to avoid police. Why? Because with all these stories on YouTube and all the stories in national news about people not having the best contacts with law enforcement, especially the ones that aren't perceived to have done anything wrong, and bad things happen, it's only natural for people to have a fear of any contact with police, even if they've done nothing wrong. Now, Justice Evans listed names of 35 people killed in interactions with police in recent years, including Michael Brown, Tamir Rice, Freddie Gray, Stephon Clark, Breonna Taylor, and George Floyd. Due to the searing history and the present-day experiences of far too many people in the United States for generations, legions of parents in minority communities have given their children the talk The talk is detailing survival techniques on how to navigate interactions with police, all out of fear of how officers with a gun will react to them. Given this context, it is apparent while attempting to avoid police officers reflects for many people simply a desire to avoid risking one's own personal safety or death. Now, what brought this case and what's this case about? The case began when Mr. Flores was arrested by LAPD officers back in 2019. According to court records, he was standing on the street in what police described as a known drug area and a gang hangout when he noticed officers driving up, walked around a Nissan parked illegally, and ducked behind it. The incident was captured on police body cameras. The officers stopped, got out of their car, and walked over to Flores, who was bent over and appearing to be moving his hands around his shoes. Maybe he was just tying them. They told him to stand up and put his hands behind his head, and handcuffed him within seconds. Now, according to the ruling, Officer Daniel Guy later testified that Flores acted suspicious by attempting to conceal himself from the police behind the vehicle and then pretending to tie his shoes. I was right. Now, as the officers patted down Flores, the lights on the Nissan blinked, which they assumed was because their frisk had pushed a key fob in Flores' possession. An officer said that when he shined his light in the car, he saw what looked like a drug pipe. The officers entered the vehicle and allegedly found a folded dollar bill containing methamphetamine and a revolver in a backpack. In court, Flores attempted to suppress that evidence as improperly obtained, but his motion was denied by a lower court judge who, as Corrigan wrote, reasoned that Flores' act of ducking and remaining hunched over behind a vehicle and toying with his feet, i.e., tying his shoes, even after officers approached and told him to stand up, was odd behavior and suspicious. But how many times have we heard it? Suspicion, mere suspicion, is not a crime. And the lower court said that Flores had done more than enough to warrant his detention. Another case where a lower court has no idea about the Constitution, and it takes a higher court to step in and go, And it takes years for this to play out. And this has been held over this guy's head since 2019, and he's just now being vindicated, and it took the case going all the way up to the California Supreme Court. It's ridiculous. Sometimes justice is not only blind, but yes, justice is very slow. Flores was ordered to serve probation after pleading no contest to a single gun charge. He continued to fight the outcome, and the state Supreme Court took his appeal. Thursday's decision sends the case back to the trial court so that Flores can withdraw his plea and the court can grant his motion to suppress the evidence against him. How his case might proceed from there is unclear. In a statement to news organizations, the Los Angeles Police Protective League defended its officers' actions in this case. For most residents living in high-crime neighborhoods, that's called good police work, said the union. The police union stated, "Yet, in their infinite wisdom, California's out-of-touch Supreme Court overturned 2 lower court rulings that found the officers acted lawfully and sided with the drug and gun possessing owner of the illegally parked vehicle to further cement California's criminal justice system as the joke it is." Suspicion is not a crime. All right? Avoiding the police who have no RAS at all is not a crime. You can't detain somebody for odd and suspicious behavior alone. You have to have a reasonable belief that criminal activity is afoot. What criminal activity did they truly have evidence of? Not just a hunch. Can't have a hunch. Hunch is not good enough. But what criminal activity did they suspect and have a basis, a reason to suspect? Again, not just a hunch. Can't have just a hunch. Hunches, can't have just a hunch and act on it. Unless it's a consensual conversation, of course. They had none. At all. Zero. Yet they detained a man without RAS, patted him down, which, if it was a legal stop and a legal detainment, they can pat down for weapons, yes. Can't go into your pockets at that point. But other than a consensual conversation and a consensual stop, officers are not supposed to detain people because they don't want to communicate with them, because they don't want to associate with them, because most people out there these days see law enforcement as a danger, and not just people up to no good. Law-abiding citizens sometimes decide, I don't want to have this contact right now. I got things to do. I got people to see. I got places to go. Have you ever been driving down the street and you see a squad car on the side of the road, and as you're driving by, you look in your rear view to see if the officer pulls out and starts heading your way? I'm sure a lot of you have. Doesn't mean he's coming after you, but how many times have you checked your mirrors to see if that squad car is pulling out to go in the same direction you are? Why is that? Even if you weren't speeding, it's inherent now. People want to avoid contact with police. And avoiding that contact is not reasonable suspicion of jack squat. But California cops, specifically LAPD, want you to think it is, and want the courts to think it is. People don't want to talk to us. They have to be doing something wrong. Sometimes I just wish I could smack the union, like these judges just smacked California cops, mainly LAPD. Thank you again for tuning into this video. Be careful out there. Who knows? If you're not, we may be talking about you in the next video. Thanks again. We'll see you next time.
One of these days, these boots are gonna walk all over you.